I have a great guest on next, a lawyer, Joyce Smithey. She is in Maryland right now. She is an expert. She tries employment discrimination, especially those involving sexual harassment. So we're going to be speaking with her for the next 5 minutes. Chat room, get your questions ready. Joyce, how are you?
I'm just fine. How are you?
I'm great. I'm so excited to have you on to talk about this area of the law that a lot of lawyers, including you, have been fighting for decades to make it more expansive. Tell me how the Me Too movement has affected sexual harassment, employment discrimination cases around the nation.
Yeah, that's a great question. I think there have been upsides and downsides. I think the upside is we're seeing more claims getting filed. Certainly the EEOC is reporting that they've had more sexual harassment complaints filed over the last year. So we're seeing more people coming forward. I think that's a positive development. Another positive development is we've seen legislative efforts to address the problems of people coming forward and confidential settlement agreements and arbitration across the United States and in federal court. And then there's been some negative problems due, I think, to the fear that executives may have of being perceived as violating the sexual harassment laws.
And Joyce, one of the things we heard from our own Jesse Weber, who was in the courtroom this morning, that there was a cross-examination line and suggesting or talking about the whole idea of a quid pro quo. The way the industry in the media was, you sleep with me, I get you apart, but that is consensual. Is that consensual under the law?
It depends. Certainly, it's very fact intensive, but there certainly is a claim for sexual harassment, quid pro quo. And it's whenever a supervisor or somebody at the management level is tying employment benefits, anything that like a promotion or keeping their job, and ties it to consenting to sexual favors, putting up with flirtation, all the different ways it comes. No, that's not legal. Certainly you can have truly consensual relationships in the workplace, but if there's a quid pro quo where someone is being asked to provide sexual favors in exchange for a work benefit or a job, that is not legal.
And then let me follow up on that. It used to be that there had to be sexual harassment when they started the sexual harassment laws, saying it's illegal, but people were like, oh my gosh, it's illegal for me to make jokes. But it was initially had to be severe and pervasive. But that's not true right now. It can be one incident. As long as you say no, it's no, and you shouldn't be doing anything sexual in the workplace, right?
Yeah, I agree. I mean, certainly the severe or pervasive standard is still the standard in federal court and in many of the state laws out there, but it's severe or pervasive, and severe can be one incident. Certainly, I've had cases where there was one very egregious sexual assault and nothing else, and that's certainly going to meet the standard under severe. Pervasive is more the continuing type of conduct, language in the workplace, inappropriate images in the workplace, conversations, and that has to be at a pretty high level of frequency. But it is true that if the conduct is severe, one time is enough to create liability.
If an employer, a high-level employer, let's say someone like Weinstein, we'll call him Mr. Smith, assaults or rapes a woman who is looking for a job in the company or is employed in the company at a job, even if it's a stamp, an equal job, that's still a crime, isn't it?
It is. Title VII and the other statutes that are out there, again, many states have their own version of Title VII. Certainly they cover applicants as well. So it's not just employees, but it can cover you at any point in the employment process, including as an applicant and as a former employee, should you retaliate against somebody after they have ended the employment relationship.
And the employer, if it's a high-level employment like Weinstein, the company has liability in this day and age automatically, correct?
Automatically if, and the legal term is imputing knowledge to the employer. One of the elements you have to prove is that the employer was on notice that it happened. And that can happen in a couple of different ways, either through a complaint.
Joyce, you know what?
Yeah.
That hard break I told you about, we're coming up. So I want you to text me your Twitter account. I will then retweet you any questions we have from the chat room. And thank you so much for coming on to discuss women's rights, and not just women, men too, anyone who works for a living, and their rights in the workplace.